a mother of 16 children living in filth and confinement. But was she a perpetrator or a prisoner herself, married at 15, cut off from family, indoctrinated into paranoia? Her attorney isn't just arguing incompetence, he's asking if her mind was ever really her own. Ohio prosecutors point to concealment as proof of guilt. But the real question is darker. Can you punish someone whose capacity for choice was dead long before the police ever arrived?
Is prepared to provide a more detailed accounting of his concerns and the specific conduct, giving rise to the concerns directly to the court and eventually to the evaluating medical professionals. So Stolle is signaling that he would like to share the information with the judge.
Counsel is prepared to provide a more detailed accounting of his concerns and the specific conduct, giving rise to the concerns directly to the court and eventually to the evaluating medical professionals. That sentence, filed in an Ohio courtroom, is a door cracked open just a few inches. We can hear something moving behind it, but the attorney is making sure the public stays outside. The paperwork already knew.
Counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense.
Think of a closed evidence bag, sealed not because it's empty, but because the full inventory is too volatile to read aloud in open court. That is the procedural posture of Elizabeth Ciders' defense right now. Her attorney, Tommy Stolle, didn't file a standard discovery motion. He filed a statement of concern, a signal that the quiet inside that bag is about to break.
That the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense.
He wrote that his interactions with his client, spanning numerous occasions and extended periods, lead him to believe she may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense.
Interesting question. I think this case, more than a lot of the others, really shows the interface between mental health and law. And it really demonstrates how when you take the same set of facts, whether you're the prosecution or the defense, you can tell a very different story. And as you pointed out in the beginning, here we have Elizabeth.
In plain terms, the person who gave birth to 16 children currently named in a felony child endangerment case may not be mentally present enough to understand the charges against her. The motion operates on two parallel tracks. If a forensic examiner finds her competent to stand trial, the defense simultaneously asks the court to consider whether she was legally insane at the time of the alleged offenses.
The defendant undergo an evaluation to determine if she is not guilty by reason of insanity because she was suffering from a condition which would produce legal insanity at the time of the alleged offenses. Defense counsel makes this motion in good faith.
It's a legal fail-safe designed to catch a mind that might be technically functional today, but was shattered at the moment the state says the crime occurred. The state's narrative laid out by the prosecutor depicts a house of hidden children and physical harm. The defense's counter-narrative is written in a different language entirely. It's a language of isolation and alleged indoctrination.
A child, 15 years old, goes through 18 pregnancies. I think she lost 2 that were conjoined twins. Mm-hmm. And you have to ask yourself, was Elizabeth groomed? Was she isolated? Was she controlled? Was the activities of the family dictated by her husband and the in-laws? She may have been trapped in an environment in what we call...
She was a child herself, married at 15, pregnant, and cut off from her own family. The defense's skeletal framework, visible even now before a full indictment is filed, asks a single devastating question. If a person is raised inside a cage, at what point can the law expect them to recognize they have the key? The paperwork already knew.
Consequences of her actions at the time of the alleged offenses, should such actions have actually constituted criminal conduct. All of this
Stolle's motion goes further, stating the mental condition would have affected her ability to understand the wrongfulness of her conduct at the time of the alleged offenses, such that the defendant would not have fully understood the consequences of her actions. This isn't just a competency request. It is a direct challenge to the required mental state for a criminal conviction.
Experts in this case to show that Elizabeth may not have had the psychological mechanisms or abilities to leave.
To convict, the state must prove not just that she failed to act, but that she knowingly did so. The defense seems to be laying the groundwork to argue that the volitional part of her mind was not hers to control.
Perpetrator, what we see is that no matter what she was going through, she had a fundamental duty to care for her children and not allow 16 children to live in a 12 by foot 12 room in human waste. But if we see her as a victim, then we say, but due to her intense abuse, control, manipulation.
Here is the brutal cognitive dissonance the court must weigh, no matter what she was enduring. Elizabeth Ciders held a fundamental duty to care for her children, and not allow them to live in a confined room in human waste. But if we view her through the lens of coercive control, the legal system must ask a chilling question. What if her capacity for choice was a dead battery in a machine still walking around?
Woman syndrome, they're going to need to link it up with expert testimony. And in the state of Ohio, if they're going for the insanity defense, they're going to need to show that because of a mental illness or mental defect that she did not appreciate the wrongfulness of her actions. And in that situation, the obligation is on the defense to prove it.
This is where the national security of a child's bedroom collides with the insanity defense. In Ohio, the legal bar requires proving that a severe mental disease or defect rendered a defendant unable to appreciate the wrongfulness of an act. Neglect is typically a crime of omission. How do you medically prove a person didn't know it was wrong to do nothing? How do you autopsy a decision that never happened?
The counter argument to that would be, well, but they made attempts to conceal it, to fly under the radar. So there's some consciousness of guilt there that we need to keep this thing under wraps and hide it from society and from the authorities.
The prosecution will likely point to a silent witness against the insanity plea concealment. The effort to hide the conditions inside the home suggests a consciousness of guilt, a cognitive ability to distinguish between a secret and a norm. That is the trapdoor beneath the insanity plea. You can't hide a crime you don't know is wrong.
Yeah, about government institutions and government control or indoctrination. It can involve a shared delusion about the outside world and being suspicious of their motives. And it could just be that they wanted to control these kids, that they received some gratification from doing that. So it could be any number of reasons. But again, if there is a psychotic disorder, and again, we've seen.
Yet, we are forced to confront a parallel darkness. If Elizabeth wasn't the architect but a victim of a broader, paranoid system involving the other indicted family members, how do we calibrate justice? Forensic psychiatrists point to the mechanics of learned helplessness and trauma bonding. A person can become psychologically dependent on their abuser, locked in a state of hypervigilance where the outside world feels more dangerous than the floor they sleep on.
Did this crime, but due to these factors, due to deep-seated psychological abuse, trauma, control, manipulation, learned helplessness, that I, don't have as much culpability, and that can serve as mitigation during sentencing.
Another part of the
If the insanity defense fails, the evidence of deep-seated psychological abuse doesn't vanish. It migrates. It moves from the verdict phase to the sentencing phase. It becomes mitigation, an argument for lowered culpability. It asks the state to punish a ghost, a woman who was physically present but mentally erased by a cycle of trauma that started with a marriage certificate signed by a 15-year-old.
time, counsel believes that the defendant's significant mental health issues would not only affect whether she is competent to stand trial, but would also have a
Stally's motion adds a damning layer, alleging the mental issues would affect her competence and her sanity simultaneously, a total collapse of rational function.
They're going to need to show that because of a mental illness or mental defect that she did not appreciate the wrongfulness of her actions. And in that situation, the obligation is on the defense to prove it by a preponderance of the evidence. So it's going to be, I think, a high bar if they're going for the insanity defense, which is.
But here is the sobering reality of the courtroom. The insanity defense is statistically rare and succeeds even less. The burden of proof in Ohio is a preponderance of the evidence placed squarely on the defense. They must affirmatively prove a negative state of mind. It is a high bar, like asking a surgeon to map a memory.
Guilty by reason of insanity, you need to have a mental illness or defect. And because of that mental illness or defect, you are not able to appreciate the wrongfulness of your conduct.
And even if they prove illness, it doesn't mean she wasn't criminally responsible. Mental illness is not a free exit door, it's merely a long, dark hallway to a heavier deliberation.
They're not saying this is temporary. They're saying this is permanent. We're going to seek to get these children into foster homes and potentially have them adopted out. That severs the relationship legally.
Yeah, as a child.
The state appears to be signaling its own verdict on future danger by pursuing permanent custody of the children, a legal severing of the relationship. This indicates prosecutors have likely seen evidence too egregious for a reunion to ever be safe.
With the other family members, what that kind of does. In your experience, does that offer some clarity for people as they're sitting in a jail cell and they have time to be by themselves and think by themselves?
It does, but sometimes it can make it worse because if there is a perverse psychological dependence on some of these other family members, that may cause her to have tremendous anxiety. We may be dealing with someone who, is unable to make decisions on her own.
The last variable is time and isolation. Elizabeth is now separated from the family that allegedly defined her reality. In a jail cell, without the immediate feedback loop of control, clarity might emerge, or as forensic experience warns, she might completely fall apart without the toxic scaffolding of that support. The paperwork already knew.
The defendant has not been indicted, and therefore, counsel does not have all of the facts, evidence, or circumstances of this case, or the defendant.
There is a document the public can read. The original defense motion for a competency and sanity evaluation is a public court filing. Go find it. Read the exact phrasing of the concerns that the attorney tried to keep sealed from you.
I'm Anjanette Levy. Thanks so much for being with me. I'll see you back here next time.
Look at the section where he outlines the conduct giving rise to the motion, and ask yourself, is this a description of a legal strategy, or is it an obituary for a volition that died years before the police ever kicked in the door?